Okay. Hi, everyone. Good afternoon. Thanks for joining. I'm going to get started in just a second. I want to make sure people log on and get to hear the whole talk today. But this is our final webinar for the year, and it's a really great way to end because we've had lots of questions about this topic over time. So let's get started. So today's topic, today's webinar, transplant webinar, is on estate planning 101. So learning about estate planning, including powers of attorney, healthcare directives, and wills. And it is going to be presented by Stephen M. Zelinger, who is an Esquire and estate planning attorney. So before he gets started, I'm just going to go through some housekeeping, which we go through every webinar. So if you've been through the webinars, then you've heard this before, but this is being recorded. So if you miss some information or it's really helpful for you, we will have it available to send to you afterwards, and we can put it on our website to be available to people. Please feel free to chat through the chat box in your Zoom. You can share where you're calling in from, you know, what your transplant story is, whatever you'd like to share. Please ask questions through the Q&A box. So different from the chat box, it's just easier for us to track the questions. And you can ask any question at any point throughout the talk today. So if you have a question about something he just said, we'll stop and have him try to answer for you. And then lastly, please consult with your transplant or medical providers if you have any questions specific to your transplant treatment. So if you've been on our webinars, you've heard about all of our other resources, but we have many virtual support groups for transplant patients and caregivers. Many of our webinars are on our website, and we are working to get many of them up on our website. So if you attended a webinar in the last few months, it might not be up there yet. And our next webinar our next live webinar will not be until January, and it'll be a patient panel. And then lastly, I want to recognize our sponsor, CSL. They sponsored all of our webinars this year, so we're very grateful for their support. They're a global biotechnology leader driven by their promise to save and improve lives. Their ability to innovate and deliver life-saving medicines for patients with rare disease and other unmet medical needs around the world has earned them a reputation for always putting patients first. CSL sees a significant unmet need in transplantation and are committed to delivering innovative solutions to address them. So thank you again, CSL, for all of your support for these webinars. So that's it for my housekeeping. So I'd like to introduce Stephen Zelinger, who we've talked many times over the last 3 years prior to COVID about offering these sessions. So we're really happy to have him here to share his expertise on estate planning. So thanks, Stephen, for being here with us today.
Thank you. Thank you, Talia. Good to be here. I appreciate you bringing me on. This is a very important topic. Obviously, one of the things I always say at the outset whenever I talk to a group about estate planning is it's pretty depressing stuff. It can be really heavy stuff. I always try to bring a sense of humor to it because I deal with it every day. So if I didn't have a sense of humor about it, it'd probably be a little depressing. But I also look at it this way. All these things that we're talking about, incapacity, death, taxes, all these things, are as much a part of life as anything, right? So my approach to things is might as well just deal with them head on, understand them, be proactive. If we're proactive and we take control, we're going to feel better. A lot of clients, when they leave my office, they sign a will, they sign a power of attorney, they sign a trust. They do these sorts of things. They always tell me they feel better, like a weight's been lifted off of them. So I would always encourage everyone to do their planning, do it ahead of time when things are calmer, right? One thing I will note is that I'm an attorney licensed in Pennsylvania, New Jersey. I'm also licensed in the District of Columbia. So if you live, and I understand a lot of you do, in other states, you would need to consult with an attorney licensed in your state. Usually your state of residence is where your attorney would be from and be licensed. If you need a name, if you need a recommendation, if you want a list of people, I'm happy to provide it. I am in a national network of attorneys, most of whom specialize in estate planning and related issues. And there's a pretty good chance one of them will kind of fit the criteria that you're looking for, okay? So I'm also going to share my screen a little bit here as well. So a little bit about me. This is my contact information, obviously. I know Talia is going to share it later as well, but if you want to call me, call me. If you want to email me is probably best. Just so you know a little bit about me personally, I live in Philadelphia. Like I said, I'm an attorney specializing in estate planning, and I'm licensed in Pennsylvania, New Jersey, and DC. This is me in kind of near downtown Philadelphia with my wife, Erica, on the left, and my son, Elliot, and Zoe, my daughter. This picture's a little old. They are 13 and 9 now, so this is a little old, but this was the best photo that I thought I had of them. Okay. Now, and again, I do encourage questions from you, so please let me know. Talia's going to interrupt me to ask those questions, because I don't want to just drone on and on if it's not helpful to people. So what is estate planning? Well, estate planning is an overarching term for all of these things that we're talking about. So incapacity planning, death planning, dealing with taxes. Some people equate estate taxes and estate planning together. They are not the same thing. Estate taxes are taxes on people who are usually pretty darn wealthy, right? And most people don't have estate tax issues. Right now, a married couple would have to have $24 million plus in assets before they would have an estate tax at the federal level. That's probably about to come down. So if you follow what goes on in Washington right now with some of these bills that are being passed in Congress, some of those numbers could come down to set the wealth level lower, but most people still aren't going to have an estate tax. Some states also have their own separate inheritance tax. So an inheritance tax would be, okay, I have property, I'm giving it to certain people that might be related to me, like a child or a spouse or someone else, and there's different rates. Pennsylvania, where I practice, there's an inheritance tax. So usually if someone dies and they give it to their spouse, there's no inheritance tax. But when it goes to kids, it's a 4.5% inheritance tax. I do try to fill my presentations with sort of war stories and things about actual cases that, that I've seen or that I've heard about. And I would note, again, estate planning is about incapacity. It's also about death. It's also about sort of taking control of the situation in terms of, do I want the law that's already written, like the defaults, to take control of things? Or do I want to take control by writing a will, by having a power of attorney, by having those things? If you write a will, you can say who's in charge of your estate. If you don't write a will, it would be certain people, how they're related to you, could handle your estate. If you write a will, you can say who gets your property. If you don't write a will, the state that you live in would say how your property is divvied up. Good example of that would be Pennsylvania versus New Jersey. If I die in Pennsylvania, even if I have children all of my marriage and I die without a will, the estate is split up between the spouse and the children. In New Jersey, if I'm married and I have children all of that marriage, all the property goes to my spouse and none of it goes to the children, right? So there's a big difference there. Most people write a will, they do what I call an I love you will. And I love you will is, I love you, honey, here's everything. You're my spouse, you just get everything and it goes over to you. And that's what most people tend to do when they do a simple will, because they don't want to give money like half the kids and half the spouse, because they figure, hey, they're going to give it to their spouse and their spouse is going to handle the money. That's definitely not the only way to do things, but that's what a lot of people do. So again, doing planning usually makes things cheaper and easier, and we can take some more control of things, right? So again, a little bit more on the differences between wills and no wills. So, most wills are going to say, hey, if I die, anything that I own, use those assets to pay my debts and pay my taxes. One thing to remember about wills is that nobody's really entitled to any property until all your debts are paid. So if someone has more debts than assets, they could essentially have a bankruptcy of their estate, an insolvent estate. There's more debts than there are assets. In that case, nobody would inherit anything. And again, when we think about this, we want to think, clearly about who is my executor, who is the person who will handle these things. If I have a will, the person that handles those things is called my executor. If I don't have a will, they're called the administrator. it's the same basic role, which is to take care of debts and take care of taxes, right? And then generally, most wills are going to say, give everything I own to my spouse, or give everything I own to my children, or give everything I own to my spouse in trust, or give everything I own to my children in trust. If I die without a will, I don't have those types of choices in terms of holding assets in trust, right? The reference is a few years old, but if you remember when Prince died a number of years ago in Minnesota, all these people sort of came out of the woodwork saying that they were related and they were children to Prince. He didn't have a will. So what he could have done is acknowledged people that were related to him and maybe not given them anything, and then given the property to who he wanted. In his case, he didn't have a will, so the law said who got his property, and then all these people were trying to say how they were related. Another thing about having no will is that a lot of times the administrator who handles it rather than the executor has to post a bond. A bond is like an insurance policy on the estate to make sure that this administrator doesn't take all the money and run and not pay creditors and not pay the money out to the ultimate beneficiaries. So a bond can be a couple $1,000s a year in some cases. It would be a lot cheaper, even at least in a simple situation, to just write a will and avoid the bond requirement. I had a so there was a question that someone asked that says, what does in trust mean? So in trust means I'm holding the assets for the benefit of another person. So if I have assets and I leave them to say I'm a single parent, I've been widowed for years, I'm an adult, I'm older, I have 2 children, right? I can leave those assets to my child in trust, meaning I can say, hey, best friend, brother, trust company at the bank, hold these assets in a trust for the benefit of my children until 10 years after I die. If they're younger, until they're 25, 30, 35 years of age. So I'm going to go into that a little bit more, but that's a good question. Now, another thing to think about here is going to be, another thing to think about when we think about wills and trusts is going to be, what are the other ways that I can pass assets? Now, this gets a little confusing, right? And it is confusing. So we have what we call probate assets and non-probate assets. Probate assets are assets that pass under my will or under intestacy, like I was just talking about if I die with no will. But most of us have a lot of assets that are not probate assets, meaning I have a beneficiary designation on life insurance or a retirement account like a 401k, or I have a joint with survivorship account with my spouse or someone else, or I have a house that's joint with survivorship. Okay, so you have to remember that how you own what you own determines what happens to it during your incapacity or at your death. So, for example, if I have a 401k from my employer, that is my individual retirement account called a 401k. That's my money. It's only my money. I can't transfer that money to anyone else without severe penalties. I have that money grows, it grows tax-free until I start taking the money out. What if I'm incapacitated? If I'm incapacitated, I need what's called a power of attorney for someone to access that money, and I'll talk about that as well. If I die, if I've designated a beneficiary, that person doesn't have to worry about my will. They just go to the Fidelities of the world or the HR department at my employer, and they fill out a beneficiary form to take that money over to themselves. And there's different consequences to how you do that, but that's a non-probate transfer. That's kind of like a little will that I wrote just for that asset, right? So similarly, if I have a joint bank account with my spouse or with my child, joint with survivorship says if I die, I'm dead, my interest, my ownership in that property disappears and it slides over, if you will, to the surviving person. That's like a little will that I wrote for that asset. That's how most people own their house if they're married and they buy a house together. You'll see on the deed, look at the deed to your house if you get a chance. If you have a house and you look at the deed, it'll say, seller, buyer, grantor, grantee. The person that bought the house might be Bob and Sue Smith, husband and wife. That means they bought it as a married couple. with the intent that if one of them died, it would slide over to the survivor. So that's joint with survivorship or marital ownership. I have another question, so I'm going to interrupt myself. The question that I got here was, I made my husband my beneficiary of life insurance in most accounts, and then our trust is the second beneficiary. Good practice? Depends on what you're trying to accomplish. So again, Michelle asked, I made my husband my beneficiary of my life insurance and most accounts, and then our trust is the second beneficiary. Good practice is the question, right? So, and that's actually a wonderful question. So let's talk about that a little bit. If I leave my life insurance to my spouse and I say, hey, you know, husband or wife of me is the beneficiary. If I die, they're going to fill out the forms. They're going to get a check for $250,000, $500,000, $1 million, whatever the death benefit from the life insurance is. That money is now theirs. It is 100% theirs. They can do whatever they want with it. They can make a new will, make a new designation on that account, cut out my children. And now maybe you want them to have the flexibility to do that. Maybe you don't. There are implications to doing that, which are obviously that someone can change it and it's easy to change. On the flip side, if I leave the assets to my spouse, for example, in trust, I might actually be able to prevent my spouse from making changes. And there's pros and cons to doing it that way. That's what we call a marital trust. Like, so if I leave the asset in life insurance to a trust or a will that I've created and it goes into the trust for my spouse, maybe they can't change it. They can't remarry and then leave it to the stepmother of my kids, right? Like Cinderella or something like that, right? So that's a little more advanced, but that's the way a lot of people do it. So some people do, honey, I love you, here's everything. And some people don't, right? The secondary beneficiary is my trust. Well, the question that Michelle asked was, you know, it's a good practice. Well, it depends what the trust says. If the secondary beneficiary, the primary beneficiary is the spouse, and the secondary is the trust under my will, and the will is for the benefit of, say, children. If the trust is structured properly, I have the right trustee, I have the right terms, that might be a wonderful way to do it. So what you said is spouse, then trust for kids, is a way a lot of people do it. But I wouldn't know in your particular situation because I haven't looked at your documents and I don't know your family situation. So this is kind of where I say, look, this presentation isn't legal advice. It's, you know, trying to give you some background. So your particular situation might be different if there's just one little fact that's different, okay? All right. Now, just looking for questions, guys. So another thing to keep in mind is there's a number of other will substitutes, right? So there's joint ownership, there's beneficiary designations, there's payable on death, POD or TOD, transfer on death, or in trust for. Sometimes you'll see these designations on accounts. So if I have just a bank account or an investment account, a non-IRA, I might go into the bank and say, well, I'm alive, it's mine. But if I die, I just wanted to go straight away to this person or these people. They don't need to go through probate. They don't need a will. Now, a lot of you are probably saying, well, that seems easy. That makes it easier. Well, the problem is it's easier, but it doesn't account for all kinds of contingencies or future control. So if I do a POD to someone that died, it's in my estate. If I do a POD to someone who's young and they're a minor and they can't handle the money, it's not in a trust. It's not protected. So it's simple, it's easy to understand, it's easy to do. It's kind of like do-it-yourself estate planning, but it doesn't necessarily account for all the things that you might want to be able to do. One thing that I'm going to note at this point, just sort of like a pro tip for people that are thinking about some of these things. If you look on my bullet points here, you look at beneficiary designations for retirement accounts like IRAs, 401ks, and 403bs. There was a recent law change that's actually pretty interesting. It went into effect in 2020, right? Now, what happened was there was a change to the way in which your retirement accounts need to be distributed at your death, right? So usually, like if I have an IRA or a 401k and I name my spouse, like, again, assuming I'm married, I leave it to my spouse, they're going to be able to take what's called a rollover, a spousal rollover, and then they would be able to take that IRA out over time. So if I have an IRA, I was in my 70s or 80s, I would take that IRA out over a period of time, my lifespan. If I leave it to my spouse, they can take it out over either my lifespan or their lifespan, depending on some factors. When it goes to children or other people, it used to be that the children or other people could take it out over their lifespans. So if I'm 70 and my kids are in their 40s or 50s when I die, or in my 80s, they're in their 50s, and I leave the 401k or the IRA to my kids, if they could take that money out over 30 or 40 years of their remaining life, what they're going to be able to do is let that money grow and then only take out a little bit at a time. The Secure Act is the name of the law. The Secure Act said, hey, wait a second. We're going to make you pass those assets more quickly to your kids. So they limited that time period to 10 years. So if I had a very large retirement account, essentially I'm forcing money out to my children. So this gets a little more complicated in the ways that we might address it, but it's definitely something worth thinking about if you have a pretty sizable IRA, 401k, 403b, and you're worried about how quickly your children or other family members or whoever you want to give it to is going to get their hands on it. So that's called the Secure Act. If you Google that term, you would find a ton of media and stories about this, because this was one of the biggest changes to the way retirement assets are handled at death that there's been in years. A lot of people are calling it the new middle-class death tax. So it's a tax more or less directed at people that have IRAs and 401ks, which are primarily middle-class people. Wealthy people don't have a lot of IRAs because they don't need them. Poor people don't have IRAs at all in a lot of cases because they're not able to. But most people that work for an employer or build up a nest egg, it's in an IRA or 401k. So Congress decided to target that as a place to generate some tax. So that is, so again, the overarching thing is what's controlled by my will and what's not controlled by my will. What's controlled by that beneficiary designation and what's controlled by the will itself. Okay, that's always something that we want to keep in mind. So if we wanted to create a trust, right? So if my wife and I die in a car crash, I have young kids. I showed you earlier, my kids are not adults. So if my wife and I die in a car crash and we have all our assets, and let's say things are pretty well organized, if I leave the money to the kids in a trust, what's that look like? What's that like? So let's just say the life insurance that my wife and I have from work or privately, our house is sold, there's proceeds, we have some cash, we have some investments, maybe we have some retirement accounts. Where's all that money going if my kids are young? Or where's all that money going if I have concerns about how my beneficiaries would handle that money? Well, I'm probably going to tell most people to put it in a trust. So the earlier question I had is like, what's in trust mean? It's like a box, right? So when I sign a will or a trust document, a lot of times it's not really kicking in until after I die. And it's like an empty vessel that's going to receive all these assets. So I think of it as a box and I put the money in the box or the assets of any type in the box. And the thing that trusts all have in common is there's money. So it might be like $1 initially and then a lot of money when I die. But they have money or property and they all have what's called a grantor, a creator, a trustee who manages it, and a beneficiary who benefits from it. So when somebody comes to me and they say, I want a trust, my first question is, well, what for, right? A trust is a very basic term. So what is the benefit of having it? Why do you want to have it? Who's it for? What are you trying to accomplish? In my case, in my example, it's for my kids because they're too young to own property, right? So there are many types of trusts. A lot of trusts are, for people that are just trying to protect against little kids, right? Like I have a baby, I bought some life insurance. God forbid we both die, both parents. I want to leave the money to someone who's young. How do I leave it to someone who's young? And that's really the purpose. But there are a lot of different, right. So the question that someone put in here, they put revocable versus irrevocable, right? So that's kind of the key question. That's a little bit of a complicated question, but a revocable trust is really just another type of substitute for a will. So a revocable trust is a trust that I can change freely while I'm alive, just like I could change a will, just like I can change my beneficiary designations and all those things. An irrevocable trust is a lot more serious, at least if you do it now. That's transferring actual assets and control to a trust where I don't control it anymore, right? Why would I do that? Well, the main reason that I would set up an irrevocable trust would be I don't want the stuff anymore. I got too much stuff. I don't want it to be taxed by the government when I die, but it's not mine anymore. So I don't control it anymore. So I have to be comfortable not controlling my assets. Another reason that people set up irrevocable trusts is to avoid long-term care costs, nursing home costs. That gets into what we call elder law. But if you've ever seen someone who advertises themselves as an elder law attorney, a lot of what they're talking about is getting assets out of an ill person's name so that the family can actually enjoy the money and they don't have to use all that money for their cost of being in a nursing home or assisted living or those sorts of things, right? So revocable is changeable, irrevocable is not changeable. I will tell you, however, that irrevocable doesn't really mean totally irrevocable. There are things that can be done to adjust for law changes and changes of circumstance. So that's where you really want to get into working with an attorney to do things. So that is sort of a basic overview on trusts. And then you kind of get into like the details. So a good example of a trust that a lot of people have maybe experienced is maybe they were younger and they had young children, like I was saying, and they want to hold the money until the kids are older. Again, there are a lot of different ways you can do trust. For those of you in the audience who maybe are older and your children are adults now, you could still hold it in trust for them. You could also apply this to grandchildren, or you could say, hey, I'll leave my money outright to my kids if they're over 35, but if it somehow falls to my grandkids because I have a deceased child, God forbid, it's held in trust for them, just as a fail-safe to make sure that they have, they have some protection until they're more mature. So in the example I gave you before, my wife and I die, we dump everything into a trust. The trustee is the one that has the discretion to pay for the kids' health, education, maintenance, and support. Those are legal terms of art that you tend to see in these documents commonly. You can think of it as maintaining their standard of living, right? Or we've set a standard of living because we live and we'd like to continue that. But that's only possible if I provide enough resources, like life insurance would be a good example. And then typically we take that money, we invest that money grows in the market, just like you would grow your money if you put it in some stocks and mutual funds in an investment account. So that money grows. The reference here to income is the money makes money. So the money grows in value, like stocks grow in value, and some stocks throw off dividends. Savings accounts throw off interest. Rental properties throw off rental income. Sometimes we distribute that money, sometimes we hold it. At the end of the day, most people that have a trust like this just want to make sure that whether it's income or principal, like the underlying funds, that there's enough money to care for the needs of the person who's the beneficiary. And then a lot of trusts will say, hey, just dole it out over time. When they hit a certain age, give them a chunk. They hit another age, give them the next chunk. The problem with doing it this way, which is, might give us a problem, might not, is that once the money's out, it's not in trust anymore. So if it's not in trust anymore, the kid has it. So if the kid or whoever it is, it's a beneficiary, has it, they can gamble it away. They could invest it. They could start a nonprofit. They could get sued and the money goes away. They could commingle it with their spouse and then get divorced and then the money goes away. So while we would like to give the money to maybe our beneficiaries so that they have it and they can use it at their leisure, there's a lot of reasons not to give them all the money at once or not to give it to them fully at all, because the more quickly we give the money to them, the more likely they are to perhaps dissipate it, right? So that's a good example of a trust for like a younger person. So, sorry, I was just looking at the chat. There was a question in there. So that is trusts. Now, so let's talk a little bit about powers of attorney, right? Now, when we think about a lot of these things, we're kind of walking along through life. We could become incapacitated at any point, right? It could be tomorrow I get in a car accident and I have a head injury and I'm incapacitated until I die. It could be that I'm older and I develop dementia or some sort of diminished capacity and I need assistance. So most people will experience some period of incapacity. So the only thing we're talking about now is incapacity. So before you die, right? All the stuff I was talking about before is post-death, right? So only post-death. So when we talk about a power of attorney, we're talking about that period of time when I'm incapacitated. So let's talk a little bit about guardianship and powers of attorney. So guardianship, I will say, this case of Britney Spears, okay, which has been in the news a lot, is not a good example of what it's really like with a guardianship. But it has brought to light some ideas that might be, might have got you thinking, right? So Britney Spears, in my opinion, from what I've seen, I don't know the case, is not incapacitated, right? But so it's usually someone with dementia or more advanced conditions, right? But the same principle applies, which is if I'm under a guardianship, I have someone who maybe I don't know or don't approve of, asking a court to declare me incapacitated and then take control of my health, so my body, and my finances. So that's a big deal. And courts don't usually take away someone's right to self-determination very, very early. So we really have to think about, we really want to avoid guardianship. If someone were to call me and say that they have a family member who it does not have capacity anymore, they're going to need a guardianship. I'm going to need a pretty large retainer check to pay my legal fees for all the things I need to do to get a guardianship. Whereas if they had just done some pre-planning when they were okay, they could have done powers of attorney. So the things that they would do in terms of a power of attorney would be a general power of attorney, that's money, and a healthcare power of attorney, obviously that's your body and your health. So a general power of attorney for financial purposes is a very important document. Sometimes it's the most important document you sign, or it's as important as any other document you would ever sign in estate planning. It's a general, durable power of attorney. Generally, do anything that I could do. It's durable. It survives incapacity. So it's there for the period of time that I can't manage my own affairs. And it's a power of attorney because I'm called the principal. I name an agent. Agent steps into my shoes and makes decisions for me. So a lot of what's in a financial power of attorney is pay my debts, pay my basic needs, do my investments, sell my house if it's time to sell my house for me and put the proceeds in investments or accounts. So those kinds of things, do my taxes, all that sort of thing. There's also other powers in a power of attorney that can be there that are a little more complicated. Those could be gifting, right? So say I have more money than I need and I want to give money to my grandkids to fund their college. So I give a few thousand a year to a 529 plan to pay for college for my grandkids. That's gifting. And my agent could do that for me if I can't do it anymore. So if I give those gifts every year and I can't do it anymore because I don't have the ability to do it because my mind isn't working so well, I can have my agent do it for me. I have a pattern of gifting. Another reason that people make gifts is to, as I mentioned a little bit before, avoid using the money for long-term care costs, right? So Medicaid and elder law planning is kind of a seminar into itself. But if you don't have the power to make those kinds of transfers and gifts in your power of attorney, you can't do it, right? If you're under a guardianship, you can't make those kinds of gifts and do those types of plans. So usually what we're trying to do is we're trying to say, okay, I got this much savings. If I see the writing on the wall and I'm going to have a long period of long-term care, it's probably pretty likely I'm going to eat at least, maybe not all of it, but eat largely into my savings. Would I rather my savings that I've built up over the years go to the nursing home or to the nurses or whoever's caring for me? Or would I rather it go to my family members who I love? Usually it's the latter. And we don't want to be forced to use all our money for our long-term care. One thing to remember about long-term care in the United States is that Medicare and health insurance do not cover a nurse who visits you in your home beyond like 60 days, does not cover assisted living, and does not cover long-term care. Those costs can be anywhere from a few thousand up to $10,000 or $12,000 a month. So do the math and figure out how long you could end up in a nursing home. And you could see very quickly your assets are going to be depleted. So what a lot of people do is they kind of see that coming down the pike and they say, is there anything I could do to move or transfer those assets to protect it from those growing long-term care costs that I know are coming? The best thing you can do is just save your money. The second best thing you can do is buy long-term care insurance. And the third best thing you can do is if you don't have a chance to do it yourself and go to the elder law attorney, you have powers in your power of attorney to save those funds. So if you've ever heard of someone saying, hey, I'm going to deed the house over to the kids to keep it away from the nursing home, taking it out from under me. I've heard people say that kind of thing a lot. They kind of got the idea of what they want to do, but they're going about it the wrong way. There is a better way to do it, and you have to talk to an attorney to do it that way. And you probably want to find someone, if you're doing that, who specializes in elder law and elder law issues. Now, so that's a general power of attorney. That's the financial. Basically, everybody needs one, right? Every single person has something in terms of assets, whether it's just their Social Security check or millions of dollars to save. They need it. On the health side, we have a few things going on here. The main thing we usually have, and this differs from state to state as to what it's called exactly, but usually have a healthcare power of attorney, an advanced directive that a lot of people call a living will. And there's also something called a PULSE in Pennsylvania. It's an order for life-sustaining treatment. So these are all kind of different things. There's also an out of hospital, do not resuscitate order and things like that. So all of these things, as you kind of go down the list, or as we get closer and closer to death, or we're in a terminal condition, right? So most people should have a healthcare power of attorney. So if I'm incapacitated and I can't make health decisions for myself, I want somebody to make them for me. It's that simple. I make them myself until I can't. It could be my spouse, it could be backup people, right? An advanced directive or a living will is simply, okay, if I get to an end of life stage, I want to give some guidance to my surrogate, my health agent, to decide what to do at the end of my life, right? So it's a more general kind of thing. Qualifications for elder law attorney. So so someone had a question, which I'm assuming is what are the qualifications for an elder law attorney? If you're looking for someone that does elder law only, I do more general estate planning. I don't specialize personally in elder law, although I do a lot of stuff kind of related to it. But if someone's in like crisis mode, I would look for someone who is accredited by the National Academy of Elder Law Attorneys, NAELA, National Academy of Elder Law Attorneys. There is an accrediting body for elder law attorneys that if you have someone that has that accreditation, you can be pretty certain that, that they know what they're doing because they've been through a lot of extra training. I am not a certified elder law. There you go, National Academy of Elder Law Attorneys, NAELA. It's in the chat box there. So that's a good resource. And they actually on their website have a find an attorney link, so you could find someone local to you. And I will say, they charge you for sure, but it's usually worth it. And if you're in Pennsylvania or New Jersey, I have a few people that I pick if someone have like bright line elder law issues. If you don't have elder law issues presently, having the powers of attorney set up ahead of time is usually sufficient. And then we can kind of deploy those powers later. How much can we plan to spend on estate planning? It really depends. Okay, it depends on where you live, what your assets are, what you're trying to accomplish. It really depends. It's all over the board. I think it's probably unfair to give you a hard number because everybody's situation is vastly different. And attorneys charge different based on their expertise, their experience, markets, things like that, just like anything else. I would not expect to work with a decent lawyer and pay like $500 for a good estate plan. Just get that idea out of your head, okay? We're talking about everything you've ever owned. There's a lot of expertise. It's a very difficult area of law if we really get into it. People want to do this like online, on LegalZoom, on all these things. I just don't think it's the right way to do it. I think it's worth investing time and energy and having a relationship with an attorney rather than I just want a set of documents, right? Estate planning could be $1,000. It's usually not that cheap either. It could be $1,500. It could be $10,000. It really depends. Most people that I work with, tend to be, $1,000, $1,500, $2,000, $4,000. Just depends on what we're doing. But usually, by the time you get through the conversation about what you're doing, you would understand the value in what you're doing. So you would say, you know what, that's a little bit of insurance on my legacy to the next generation. So I'm willing to spend it. I had a question here. Is someone with dementia able to set up their child as POA? Can it be as simple as a notary visit? There's a lot packed into that question. Is someone with dementia able to set up their child as POA with assistance? Can it be as simple as a notary visit? Okay, so there's a couple things to say here. Number one, they have dementia. So someone with dementia can have capacity, but lawyers sometimes have to assess capacity. So like I use a rubric to decide whether I think someone has capacity. So that's number one. If someone doesn't have capacity, they cannot sign a power of attorney. They don't understand what they're signing. How can they sign a power of attorney? So that's bar number one. And that can be tough, especially with older people and people with dementia and things like that. Again, you can have a moment of lucidity where you could sign it, but of course you could have questions later about how did you know and medical records and all those things. So the other part of this question is can they set up their child? Well, certainly if the client goes to the lawyer and asks for a power of attorney and they're competent and privately with their lawyer without influence from other people, they decide they want their child to be the agent under the power of attorney, they can certainly do that. a lot of times people will come to me, kids with their parents, and I'll talk to the kids and the parents together at some points, but I always talk to the client. When the attorney is approached to do the work, the first thing we need to do ethically is ask, who is the client? The client is not the child who wants their parent to get the power of attorney in order or the estate planning. The client is the parent or the parents. So we always have to be very clear on who is the client, and does that client have capacity, and is that client making decisions of their own volition, right? Very, very important, otherwise we're gonna have problems later. Is it as simple as a notary visit? A notary is simply a person who verifies that you are who you say you are. A notary is not a lawyer. A notary should not and does not draft legal documents. So you do need to have notarization on a lot of documents, or at least it's a good idea if it's not required to have notarization on documents, but it's not as simple as a notary visit. Have your parent go to an attorney who does this every day. That's probably the easiest way to answer it. My mom has medical power of attorney. Someone asked the question, my mom has medical power of attorney over me. I don't believe she will do my wishes I want. What should I do, or who should I talk to? Well, I don't know the person's age, number one, and I don't know their condition. So we would need to know, again, whether the person who feels like they're not being taken care of properly has the capacity to revoke the power of attorney and name a new one. So the person asked, they have medical power of attorney over me. Is that because the person signed a power of attorney, or because they're under a guardianship? If they're under a guardianship, they probably don't have a say, or as much of a say in their wishes. So if you have capacity enough to draft this question and write it in the chat, you probably have capacity to talk to your own attorney. So if someone comes to me for a guardianship and they say, hey, my parent needs guardianship, I represent that person who petitions to be the guardian of that person who they say is incapacitated. That incapacitated or alleged incapacitated person has the right to an attorney just like anyone else. In some states, they put in place what's called a guardian ad litem, right, which is a person identified as a neutral by the court to represent the interests of that person. Britney Spears, again, had a guardian ad litem to represent her interests, okay? Okay, so what qualification checklist for attorney should one look for? That's a good question. Well, I don't know that there's one overarching checklist, but the things that I would typically ask the attorneys is, how long have you been doing this? How many clients do you have? What percentage of your practice is estate planning? One thing about estate planning, or about law in general these days, is there really aren't any general practitioners. If you go to someone that's a general practitioner that does divorce and does litigation and does criminal defense and does some estate planning on the side, run for the hills. They don't possibly have enough experience to do it and do it right. If you want someone to pump out a form and not spend any time with you, by all means. But if you want somebody to sort of do right by you, you go with someone who will talk to you and does this every day. When I do initial consultations with people, I do them for 90 minutes for no charge. And then most people at the end of that, they hire me, so it's worth my time in terms of being a person who does this, for a living. But most attorneys will do free consultations. Not all, doesn't mean that's the end all. They will charge you, usually for estate planning, a flat fee. I always set a flat fee at the beginning based on the complexity or the protections in the plan. So we both know what the fee is going to be. Other things to look for would be, what's their approach or their availability after you sign your documents and you want to update things? What if I want to have a conversation with my attorney about the right way to set up my beneficiary designations, like on my work life insurance or my work 401k? If I have questions or I don't know what to do about something, will they direct me to another attorney who does? One thing that I will say about specializing in estate planning is I don't do litigation in terms of, civil lawsuits in most cases, and criminal and family and all that stuff. But I know people that do. So because estate planning touches so many parts of people's lives, I have a pretty good, from doing this for a while, I have a pretty good number of contacts in my area and really across the country that I can, send people to. So another question I had here is, how about companies such as Schwab that offer trust services? So what Jim is asking is, can you use a professional trustee? And the answer is absolutely yes, you can. So Some localities will have local small trust companies that do trust services, trusteeship, and some people use large banks. Large banks or large trust companies, if anyone's from the Philadelphia area, they probably heard of like Wilmington Trust, Glenmead Trust, these big trust companies. Usually those trust companies have pretty high minimums, like in several $1 million before they will handle a trust. Some other trust companies will take smaller trusts. So I work with a couple of trust companies, at least in the local area in Pennsylvania, where they specialize in special needs trusts. So say the parents had died and they have a child who maybe has like a pretty serious disability like Down syndrome. That child might need help throughout the rest of their life. So they might have a trust, a special trust for them that is meant to protect their benefits that they might receive from the state. That's called a supplemental needs or special needs trust. That's a very specialized type of trust. And you definitely need an experienced trustee to administer that trust. Professional trustees like banks and trust companies charge for their services. Although anybody who serves as a trustee, even if they're a family member, can also charge for their services. So there is a cost to it. Think of it as running a small business, growing the investments, making decisions. Those people get paid to do that. But a lot of people do have situations. I was just on the phone with somebody earlier, actually, who couldn't decide on who to have as a trustee. And they wanted to know if they had other options. So some attorneys will act as trustee. I usually don't. I rather represent the trustee, but some attorneys will. It kind of depends on common practice where you live. But those are options. So family, friends, basically anybody who's a competent adult, usually a U.S. citizen is better, and then an entity can do it as well. Also, one thing I wanted to talk about a little bit with healthcare was, so healthcare powers of attorney, again, for your health, advance directive, end of life decisions. One thing that for people to understand is an advance directive is simply, okay, I'm very close to the end of my life and I wasn't expecting it. I just want to be able to tell the people that make decisions for me whether I want my life extended or not. Usually when we get to that discussion, we're saying, okay, I have no reasonable chance of survival or recovery. I don't want to keep living. That's what an advance directive is, simply trying to give some guidance. An advance directive is not a physician's order, right? But we might use it to put a physician's order in place. A post or an out of hospital do not resuscitate order is a physician's order, right? So it's for someone who is maybe 1 to 2 years away from death, and we want to have more, firmer wishes stated on whether that person would be resuscitated, whether they would get, their heart restarted if they went into cardiac arrest, or whether they would be put on a ventilator or something like that. A question that a lot of people have with COVID is, well, if I have an advance directive that says, if I'm not going to survive, I don't want a mechanical respirator, I don't want a ventilator machine to keep me breathing. Well, if I go into the hospital with COVID, are they going to put me on a ventilator? And the answer to that is if they think that it's going to help you get better, of course they're going to put you on a ventilator. But there might be a point in the future where it doesn't make any more sense. Or maybe I'm so ill that I probably wouldn't survive that I never want to be put on it in the first place. But you would usually be under the care of a physician and they would put an order in place. So you have to kind of know where you are in timelines. Who should get copies of these documents? So great question. Well, your healthcare documents, you should give to your doctor. If you go into a visit, bring the copies with you, have them put them in the file. There was a lot of talk about, digital medical records and all those kinds of things. A lot of that stuff hasn't gone as well in most hospitals and most localities as we had hoped it would. So give it to them. I wish there was a better way. There used to be, like when you checked into a hospital, they would ask you to fill out an advance directive. They don't do that anymore in most places. You'd have to do it on your own. Another thing that I do, since you asked the question, is I don't know if people can see it. This is a little wallet card that I hold in my wallet that there's a service called legaldirectives.com. So I don't know if Talia can type that in, but it's called legaldirectives.com. It's its own company. I don't work for them. I don't get paid by them. But you can go to legaldirectives.com and you can get a membership. If you get a membership, you get a wallet card. Wallet card goes in your wallet. In your wallet, you put a little sticker on your driver's license. So if you're ever admitted to a hospital and you can't communicate, they look for the wallet card. Using the card, they can pull off who are your emergency contacts. What are you allergic to? Who's your doctor? Copies of your health directives. So we have an easy way, because you're not going to carry around your healthcare power of attorney in your back pocket all the time, an easy way to access it. There's other ways that people do it, like QR codes and wallet cards, and all these things are different ways, but you should certainly have someone be able to have access to it. Another thing you can do is on your iPhone or your smartphone, set up the emergency contacts. If I click my phone 5 times real fast, it goes into 911 mode and it can contact all my emergency contacts, let alone if if someone picks up my phone, if I'm incapacitated, they can go into emergency mode and see who my emergency contacts are and contact them. That's also smart. I can tell you from personal experience, this wallet card was very helpful to my father. My father had, they thought he was having a stroke and he wasn't able to communicate. He had aphasia, he couldn't get the words out. And he couldn't unlock his phone because he couldn't work it because he was not doing well. And they went into his wallet, found out who he was, pulled out the wallet card, went on the website, got my phone number, and they were able to get a hold of me. So especially if you're older, especially if you live alone, this is a real godsend for that sort of thing. In terms of your powers of attorney and your wills, who should get those? Probably the people you have on your list of agents, your spouse, your brother, sister, friend, whoever your agents are. You might not want to give them the documents because you might change your mind later and not have them on there anymore, and they might get insulted. On the other hand, you might not care, in which case you can just give it to them. You might just say, hey, look, you're on my list. If something happens to me, call my lawyer. Here's my lawyer's information. You might actually share scans with them. One thing also with who should get documents would be, in some cases, you actually need the original document. This is a very kind of archaic kind of thing at this point, like digital signing and all that. Wills in most places are not digitally signed. They're physically signed with 2 witnesses and a notary present in a room with ink. So in most places, you need the original will, and there's only one original. Where does that original sit? If it's sitting in your home and your home burns in a fire or gets lost, it's lost. There's all kinds of stuff people do with wills to like pocket a will that doesn't benefit them or something like that. A lot of attorneys hold wills for their clients, not all do. So in my practice, at least under ethics rules in Pennsylvania, I give them a copy, I keep a copy, and that's electronic. You can also print that, you have physical copies. I also hold, if they want me to, originals of their wills, and I hold them in off-site storage. So I have the originals in a vault that's secured off-site, fire protected, et cetera. So I go get those if somebody dies, I can retrieve the will and probate the will. So if the person has all their estate planning documents, usually in a binder that looks something like this, a binder that looks like this, if they have it sitting in their house, the will, family goes through, pages through, finds the will. Oh, this is a copy. And I have a little stamper on it that says, this is a copy. Call Steve Zelinger's office. Now, at that point in time, if you have the original will and somebody had died and you need to administer their estate, do they have to use me as their attorney? No. I hope that they do, because that's how I make money. That's my job. But they don't have to use me. I have to give them those originals, and they can use another attorney or no attorney at all to probate it. Not advisable, but they could. They could if they wanted to. Okay, so that hopefully answers the question about originals.
Steve, hi, sorry,
yeah.
it's Talia. Just a quick, it's like almost 5:04, and people might start logging off. Sure. Since this is scheduled till 4. I'm not sure how many slides you have, additional slides.
I'm almost there anyway, and then I'll hang out and take questions, so I'll probably finish it up.
Yeah, so if people do want to stay on, if they have questions, you can do so, and he'll stay on. And then there were a few questions that were submitted.
I'll take a look. Oh, I see them. Okay.
No, so, sorry, that's submitted through registration, so I'd have to read them to you, but we can do that at the end.
So the I'll kind of leave it there. So there are a couple of questions. I'll just go through them real quick, and I'll kind of finish it up. So I can't cover everything, obviously, so I won't try. One question that I got, and then Talia, you can answer the questions, was does the city township clerk have copies of legal documents? Why and why not? So usually, in most cases, although there are exceptions, the localities do not have, while you're alive, copies of your documents. Mostly with wills, because you can change it at any time. There are some places where people log their will ahead of time, usually not. Mostly because, again, people can change them and people want privacy and things like that. things like deeds are public record. Wills after you die and go through probate are usually public record. So it's usually after you die that they become public. One reason that those types of things become public is because when you die and you go through the probate process of administering your will and your estate, is the first thing they want to do is make sure that the creditors have an opportunity to make claims. Some people call probate and the whole post-death process a lawsuit you file against yourself for the benefit of your creditors. So the world knows that you died, you have to publish notice, and then creditors get to come forward and get paid. And then there's a question that says, which documents are considered as final or binding? Not exactly sure what's meant by that question, but what I will say is the last one. So usually if you sign a power of attorney, it says I revoke all prior powers of attorney, or it says if I sign a new will, I revoke all prior wills and this is my new will. So sorry, I was just reading what someone had said. Someone mentioned in South Carolina, they have something called Smart 911. Don't know about that, but that's good. So we can look that up. Another thing to just consider, like real quickly, and Talia ask questions, is thinking about your digital assets. So your email. So one thing that we do, there's a lot of reasons to think about digital assets, like your Facebook page, your email, your music you have online, photos, all kinds of things, websites, points, Bitcoin, all kinds of stuff people have that's digital. With all your life being digital, how does anybody access your digital life? They can't get into your phone, that's illegal. They can't use your passwords, that's also illegal. So how do they get in? The best thing you can do is you can ahead of time grant access either via your estate planning documents that give digital access powers, digital asset powers to your fiduciaries, your agents, your trustees, and your executors, or for example, if you go to like your Google settings, there's something called inactive account manager, right? You might put that, it's called inactive account manager on Google. If you go to your Google settings, you can actually set up a plan so that certain people are notified 3 months after you die or don't log into your Google account, for example, and get information. So one of the ways that we would find assets when people die is we would look at their mail or we'd look at their files. Well, people don't have physical files a lot anymore. People don't get mail for bank statements anymore. So if it's all digital, how do we get it? Well, probably in their email. So if we can get access to their email and set it up ahead of time, it's going to make that process a lot easier. So I'll kind of leave it there. And if there's any questions, I'm happy to hang out for 10 or 15 minutes if there's questions. And I'll just sit here and take them, and I'll leave it at that. Obviously, there's a lot more to estate planning, a ton more. I could go on and on for hours, as you could probably tell. I didn't even really touch a lot on like taxes and things like that. And if anybody has questions for me, or if they're not local, they want a referral, feel free to ask me the questions. I'll try to get to them as soon as I can, but I'll hang out if anybody has questions, and I'll end it there. And again, I know Talia had my email address, Steve@Zelinger. You can email me.
Yeah, and there are a few questions I'll just go through pretty quickly that were submitted like via registration. One actually was about taxes. Someone had asked, how can they best position their money and other assets to reduce their tax risk and the tax risk of their beneficiaries?
Really broad and difficult question to answer succinctly. Okay. What I will say is the following. Most people that have any, reasonable, well, I'm not going to tell what a reasonable amount of assets are, but anybody that has anything they want to protect should probably have an estate attorney at a minimum, somebody like me, but probably more importantly, a financial planner and an accountant, right? Tax planning is done ahead of time, not after, okay? So if you're looking for deductions after the fact, it's probably too late, right? Tax planning should be done ahead of time. And financial planning is really the person that you should be dealing with on a day-to-day basis or like quarterly basis to think about like, where should I have my investments placed and things like that. So I wish I could give a better answer to that question. But if you need direction or guidance or referrals to financial planners, I'm happy to try to help you kind of point in that.
Yeah. So someone asked, I'm not sure if you're the best person to answer this question, but it is related to like a power of attorney, or not even power of attorney, but an advance directive. If someone like, would you or an estate attorney help someone complete an advance directive? Because sometimes it can be really confusing. Like, I don't want to be a DNR, but a do not resuscitate, but I also don't want to be on a like feeding tube, or I don't want dialysis. Like,
all right. So yeah, I mean, I would be one place to start for that. So I do advanced directives with people all the time, and I help them, and I try to simplify the process, which is an advanced directive is just a really generalized document for a very specific set of circumstances. So we don't know what your health is going to be. We don't know when this is going to happen. We don't know your chances of survival. We don't know so many things. So usually the way we handle an advanced directive is simply by saying like, hey, if you meet the legal definition of end of life and the physicians were to come out to you or your agent and say, we don't think you have a chance to survive, what would you want to see happen? Would you want to be kept on life support indefinitely? Or would you want that to end if they are making the best decision possible, right? So it's a tough one. A lot of people struggle with it, but most people that do an advanced directive do it for the express purpose of not being kept on life support indefinitely. They're just trying to say like, hey, agent, if you're getting the advice that it's time to let me go, it's okay, you can do that. You don't have to keep trying. Now, that doesn't mean that agents don't ask for third opinions. It doesn't mean that doctors aren't sometimes incorrect with how long you have to live. They're human just like anybody else. But I think that that's probably a good way to look at it.
yeah. And I would, because most people on the call are transplant or caregivers. You should definitely be looking into advanced directives because you're getting a lot of intense like surgical and medical procedures that are really important that you kind of express your wishes.
Like I said, if you're at that sort of Potzel stage, you can have a talk with your doctor, and if they're willing to, they sign it, you sign it, and together you say, okay, if I meet these criteria, this is what I want for my care. Again, that's usually if you're within 1 to 2 years, or reasonably think you're in one to 2 years of death. If it's further out, we're usually going to try to do everything we can to support you, keep you alive.
Yeah. If anyone has any other questions, like there's still quite a few people on, like please submit them. You can put them in the chat at this point. There's only like 2 more questions that were submitted early that I'll go through. So one is, can you add your children on your house so they don't have to pay an inheritance tax?
What state is that person in? Do we know?
I don't know.
Don't know.
I mean, actually, I might know. Wait, let me see. Sorry, I gotta look through.
Sure.
So they are in Pennsylvania.
Okay, so that I can answer. So usually inheritance tax avoidance is not a primary concern that people have. It's usually not like a main concern. That said, there are ways to avoid inheritance tax by making gifts or adding somebody to the deed. Usually, you should not add your children to the deed for a number of reasons, most of which are related to control, asset protection, nursing care, Medicaid, all those types of things. But if I have a house and I leave it to my kid and I list it on my inheritance tax return, they're going to pay a 4.5%, if it's children in Pennsylvania, they're going to pay a 4.5% tax on the value of that house. So they need to be able to have other money or somehow have money to pay for it. If they're on the deed with me and I get it far enough in advance, they're actually only going to have to pay inheritance tax on half of it, right? Which could be half the inheritance tax. So there are times when you would do that, but I can tell you, I can count on less than one hand the number of times that I've ever done that for that reason. So gifts made or transfers or additions made more than a year from death would reduce inheritance tax consequence, but you have to think strongly, think clearly about why you're doing what you're doing, in that.
Okay, great.
I wouldn't do that on my own. That's not a do-it-yourself thing.
Yeah. And then lastly, interested in the best way to title jointly, I'm just going to read it as it is, title jointly owned property for easiest transfer to remaining owner when ownership is not 50-50. Let me just type it in because I don't know if I'm like.
I think I kind of understand what they're saying. You got to look at the deed. I'm assuming it's about a house, so you got to look at the deed clearly, right? You got to look at how you own it. So like I've seen houses where one half is owned by husband and wife and the other half is owned by a kid or something like that. You can get into some pretty complicated stuff. So all the people in that scenario should understand what their rights and responsibilities are. Every person in that scenario should probably have a will. Because here's what commonly happens when you have joint ownership. One person dies and then their interest disappears and it goes over to the other. So I had like two spouses and now there's only one. So now the one owns it and that's it. It just happened because that's what the deed says. A lot of times what happens is say the parents die and they deed the house out to the children and there's three children. If there's three children and they own it as tenants in common, they each own a third. If they each own a third and one of them dies, that third passes to that child's heirs or beneficiaries. So now the two kids are co-owners with these other family members. And as you can imagine, if that keeps expanding out, you have like 18 owners. And if you have 18 owners, nothing good will come of that situation. I can tell you, I've dealt with it many times. So if I have a portion of a house or real estate, I can pass my portion to whoever I want. So I can only pass through my will that which I own. I can also look at the deed and say what the survivorship is. So if I can't say kind of in a vacuum what the best way to do in that person's scenario is, all I can say is that you have to understand exactly all the facts. And sometimes you need the cooperation of other people, and sometimes you can get it, sometimes you can't. But it's always easier to resolve these problems while everyone is around, competent, and can speak at the least. I've had a number of cases over the years where I had family members who hated each other and they couldn't decide what to do with a house and just ended up in family strife and things like that. And some of that's unavoidable. Some of that's just unavoidable. Like if you leave a house to two brothers, let's say, and the brothers hate each other, and I can't make them not hate each other, right? But I could maybe they each get lawyers and we can offer solutions so that they could buy the other one out or agree to sell it, give credit for whoever paid more of the bills, and then they divvy up the money. It's a lot easier to act like adults and divvy it up than it is for us to go to like forced sales and what they call partition, forced sale and litigation, which nobody wins. They end up hating each other. It costs more money. Only people that make money are the lawyers. And then everybody is just angry and they got less than they wanted. So not a good way to do it. So plan, if you're thinking about it now, go to the lawyer now.
Okay, that sounds confusing when you have all those like people in the mix. So I think that's it. It doesn't seem like anyone has any questions. There's a few people on left. So if you do have questions, I'm going to send out an email tomorrow morning that has Stephen's contact. So you can email him if you are looking for some more information or support around this. There was so many questions that if you're interested in the future in doing something like this again, even if we just fully do a Q&A and kind of come up with some topics ahead of time, it seems like people, really want to talk about this and it's good that people are.
I'm not surprised anymore, but people don't want to talk about this, but then once they start thinking about it and hear the stuff, they realize like everybody has questions about this stuff and it's very relevant. I mean, usually these questions are very relevant to a lot of people. So I'm always happy to answer.
Absolutely. Everyone should know about this. So we'll send all that information out. Thank you again for sharing your expertise, and hopefully in the near future, we'll do something like this again.
Great. Thank you, Tony. Appreciate it.
Thanks, guys. See ya. Have a great Thanksgiving.
Happy Thanksgiving. Thanks.